can get started on hearing session 1 on policy matters. Good morning. This will be the first of 2 hearing sessions planned for today and is associated with the policy matters relating to the Strathy wind farm, which is 13 turbines located approximately 8 kilometres south of the village of Strathy in northern Sutherland. I explained the context for these hearings and set out a wider introduction to the inquiry programme on Monday morning. I won't be repeating that now. It's there on the webcast if anybody wants to refer to it. As discussed at the end of our inquiry session 1, it was agreed that if possible, we would move this hearing, we would just close this hearing temporarily and move to the second hearing without a significant break. I've checked, as far as I can tell, it's the same virtual meeting platform, so any change of personnel, people joining or leaving, won't make any difference. We just stay on the same meeting, just mute the microphones and shut down the video temporarily. At the end of our inquiry session, we also agreed that as part of this hearing submission, because we had most of in fact all of the main parties would be here today, we would have our discussion on closing submissions or any other further procedure that might be needed after the inquiry closes. So we'll slot that in when we've finished the hearing, the policy hearing discussions. So that only leaves me to perhaps introduce myself. I'm appointed by Scottish Ministers to jointly with Ms Haywood to consider the matters arising in relation to the Section 36 application. That's intended to help us with our presentation of our findings and recommendations in due course. You'll see Ms Haywood is also present on the video screen. And I would just like to get today's participants to introduce themselves. We've got a slightly different arrangement of people today. We'll maybe start with Mr Fraser on behalf of the applicant.
Thank you. Thank you, ma'am. My name, as you know, is Vincent Fraser, Queen's Counsel. I'm instructed by Vincent Masons. And this morning, ma'am, I have Mr David Bell, whose report you have and who effectively, I think, will be leading our presentation this morning. And also Mr Gary McGovern again, who I think is the leader.
Mr Finlay on behalf of the Council.
Yes, good morning, ma'am. James Finlay, Queen's Counsel. I have Simon Heinson, who will be leading probably for both sessions, although there may be some dovetailing between us both.
And Mr Kelly.
Good morning, ma'am. Ian Kelly, representing Wildland Limited. It'll just be myself. I have a couple of very small points to raise with you before we start, just when you wish, ma'am.
That's fine, I'll come back to that shortly. We've circulated an agenda for this session previously, and I indicated briefly at the start of the inquiry that we would add in some discussion on the control of woodland policy, the government document and also the Council's SG. I still intend to do that, but just very briefly to set a context for that matter as it refers to things that are happening in hearing session 2. So does everyone have a copy of the agenda? I'm assuming that they do. Yeah. So I'm aware that the parties here all have experience in participating in hearings. So really for the purposes of the webcast, I'll just explain the process that we'll be adopting today. There's no formal presentation of cases. I'll lead a structured discussion following the topics set out in the agenda, and all the matters discussed are treated as evidence. I'll address my questions to the main contact for each party and give them a chance to decide who's best to respond. Other parties will also be given an opportunity to contribute on that matter. Please signal if you don't want to make any contribution, that's fine. And if I feel I've got enough information on the topic, we'll move on. However, it is likely, and I expect, that any discussion that does take place will be aimed very much on the areas where we're in dispute between the parties, rather than on the areas of agreement, and that's very much where we'll be focusing on the discussion. It will be possible to raise questions arising from the discussions, but they should be directed to me first. And please let the person speaking complete their point before raising that matter. Does anybody have any issues regarding the procedures themselves? No, not seeing any response on that. In terms of additional information, Mr. Kelly circulated to us by email the updated constraints payments. I'm assuming everybody got a copy of that. I'm content to accept that as an additional document as part of the inquiry papers, but I need to ask the council and the applicant if they agree with that approach. Mr. Fraser and Mr. Finlay?
We have no issue. Obviously, Mr. Bell will comment on the basis.
Yeah, and Mr. Finlay, are you happy that we accept the email as an additional document?
Yes, yes, I am. I mean, I am finding Mr. Fraser difficult to hear this morning. I don't know whether others are, but it may be just me, but I'm finding you very clear, but Mr. Fraser not, and it would be a shame if we lost any of his pearls of wisdom during the course of the morning.
I am sorry, is that an answer, Mr. Finlay?
Yes, it is.
I'll try to make sure I speak up then, but okay.
Okay, that's fine. Does anybody have any other matters relating to the hearing topics that they want to raise? I'm obviously assuming Mr. Kelly wants to come in at that point. Is that correct?
Ma'am, do you want me to raise my points now?
Well, I'm assuming they're relating to the policy hearing matters, as opposed to matters that you want to raise in the context of our general discussions.
Well, the first one was just a minor point, ma'am. Yesterday's proceedings were reported in this morning's Times, and I just have to say that I don't recall saying some of the things that are attributed to me by the press. So if anyone reads the article, take it with a pinch of salt, you know. Secondly, ma'am, for this morning's agenda, there was a client meeting earlier this week, and I have updated instructions. Very simply, there's virtually nothing between us and the council on matters of policy. Therefore, rather than prolong discussions, I will certainly answer any questions you put directly to me, but my instructions are really just to contribute if there's anything I want to add to what Mr. Heinsohn says, the reason being that on matters of policy, there's virtually nothing between us and the council, so there's little point in me going on about the same thing as Mr. Heinsohn will no doubt go on about. That's all. Thank you, ma'am.
Yeah, that's fine. Obviously, that's perfectly possible within the structure of the discussion on a hearing for you just to opt out of any further contribution. I think the Times and their attribution of any quotes can be confirmed by the webcast. That's the only downside. The webcast will find you out, Mr. Kelly, if you've got something wrong. Well, I think that's fine. I think we can move on to start the actual business of the agenda now. I took the precaution of just listing some 4 documents that might be relevant. I'm sure you will have spotted them yourselves, but I'll read them out in case it just helps everybody prepare before we kick off. 2.1, which is the report of handling, 9.1, which is NPF 3, 9.6, which is Scottish planning policy, 9.7, the NPF 4 position statement, 9.11, the control of woodland policy, CDs 17, 1, 2 and 3, that's the 3 statements, 19.1, the agreed matters, CD 2047, which is the late edition, which is the corrected Gordon Bush variation decision, CD 10 of 9, which is the Council's trees and woodland guidance, CD 10.1, which is the LDP, and 10.2, which is the supplementary guidance on onshore wind turbines. There may be others that crop up in discussions, and I have some additional documents that we might need to refer to during the conditions hearing, so I'm not touching on those at the moment. So that takes us to item 2 on the agenda, and you'll see that the broad topic here is UK and Scottish energy policy context as opposed to planning policy context. And the first area that I'm looking to address is the issue of the need case and the difference of opinions between the parties as to how relevant it is in its own right as part of the Scottish Minister's considerations. So the obvious place to start, perhaps, Mr. Fraser, is with the applicant, and for them to explain in what way we need to treat the need case as a separate material consideration for the ministers to take into account. I'm not looking, obviously, for Mr. Bell to repeat the need case. I think he's done that quite comprehensively in the statement, but really to focus in on how it should be handled. Thank you.
Well, I'm happy to pass over to Mr. Bell on that. Thank you.
Thank you. Good morning. Can you hear me okay? Is that clear enough? Thank you. Yes, on the first matter, I think there's 2 points in this agenda item, and no doubt the second one will come on for Mr. Kelly to give his position in the context of Gordon Bush. But the applicant's position is that the need case is relevant, but it's also an important factor in the consideration of the application. So in summary, in my hearing statement in chapter 2, I set out what I call the climate emergency and the renewable energy policy framework as distinct from the planning policy framework. And I draw conclusions on the matter of weight in my section 2.6. And in that, I think it is informative to reference 1 or 2 decisions, which I've done, Millenderdale and Paul's Hill 2. And it may be, as we come on to some of the later matters in the agenda, that we can go to a couple of these to emphasize the point. And it's linked to what comes later in the so-called proposition of double counting, which is to be covered later. I also make reference to, I think it's relevant to look at the Crystal Rig decision, which I think came in post the exchange of hearing statements, and that's CD 20.45 and 20.46, where in that, in summary, certainly in page 16 of the Minister's decision, they reference the seriousness of climate change and the need to cut emissions is a priority for the Scottish Ministers. So I think that's all I really need to say. That's how it's set out in the evidence. And we do have comments to make about Gordon Bush and can expand on some of those points on later matters of the agenda, just to save time. Thank you.
Thank you. I know Mr. Kelly was pulling back from responding too much, but obviously he made quite clear statements regarding how we should handle the need case as a concept, and he was obviously making reference to the Gordon Bush variation decision in that. So obviously this is perhaps somewhere where we do want you to make a contribution, Mr. Kelly, and just explain why you've taken such a different line on it from Mr. Bell's position.
Thank you, ma'am. It's probably not, unfortunately, it's probably not one I can help you with. When I read these words in the variation decision, I was slightly surprised because I thought the renewable energy case was all about need. Since the variation decision has come out, I've referenced it and I've referenced my view on the decision in a considerable number of scoping stage and application stage responses to the Energy Consents Unit. I've verbally raised it with the Energy Consents Unit, and I've given them every opportunity to come back with either a variation of the wording or an explanation of the wording, but I've had nothing back from them. So really, as far as I can see just now, Mr. Bell, I know, has a different view from me, but it is a matter for Scottish ministers. It's Scottish ministers who wrote those words, and it's Scottish ministers who have decided not to offer any variation or explanation of those words. I mean, I must have raised it with them about more than a dozen times, offering them the chance to clarify it. And as I say, I from my personal professional opinion, I was surprised to read what Scottish ministers say. But as far as I can see at the moment, it really is a matter for them, irrespective of the views that we all may have on it. That's all I want to say, ma'am, just now. Thank you.
I wonder if it would be useful, because the variation decision wasn't available at the time you were preparing your hearing statement. I wonder if you could just highlight which paragraph it is that you're most concerned about. I don't know that your hearing statement had actually pinpointed it. Trying to see if anybody.
I think it would be page 4. I think it would be page 4, bottom paragraph.
Yeah.
Last line. Ma'am, I've certainly got 1 or 2 comments just to make on that.
Okay. Yes, that's fine. I was expecting, obviously, for you to come back on that as to whether or not that sentence is giving a new direction on this matter.
Yeah. I mean, I think Mr. Kelly's obviously got an exchange going with the ministers, but that is not for this inquiry, and it doesn't really help you. But this has been raised at other inquiries by Mr. Kelly, and I think the answer is that this is a variation application. The Gordon Bush scheme was consented, and if one looks just on the above paragraphs, what is sought is to reduce the number of turbines from 16 to 11, to reposition a batching plant, to remove a consented operations building, and so on. And there's a modest increase in tip height on the remaining turbines by 19.9 meters. So if we look at the paragraph that I think Mr. Kelly is concerned about, the ministers have said the need case for the proposed varied development is not a material consideration. Now, whether that's right or wrong, the ministers have simply taken a view that they're dealing with the variation of this consented scheme, and for them, dealing with the need case is a matter that was already addressed in the original decision. That may be the case. So, as I said at the start, our position is that the need position is an important factor, and I think this statement has to be read in the context of it being in a varied development. Section 36C application.
Thank you. That's helpful. Can I just ask Mr. Kelly briefly, is your main concern really arising from the terms of the Gordon Bush decision, or do you have any other reason why you would wish the need case as such to be given a different priority in the minister's assessment? Mr. Kelly, you're quiet.
This Mac seems to mute and unmute to itself. Thank you, ma'am. In my view, as I say, it's a matter for ministers. I think need is important, but need is a wide-ranging concept which takes account of things like the number of consents that are unbuilt, the move towards targets, the wider policy environment. So my view is that a very wide-ranging need case, which can have positive and negative sides, is important. And I was just intrigued at this wording, which I've never managed to get clarified. But I think in the end, it's a question I keep putting back to Scottish ministers. My professional opinion, my own professional opinion, is probably not that much different from Mr. Bell's, in that I do think you have to consider a need case and give it some weight. But I probably think that there are negative factors as well as positive factors in that need case.
Thank you. Just really, does the council have anything to add or contribute on that matter?
Nothing further from what's been discussed already. I think the only other decision that I would reference perhaps in this point would be the North Lowther Energy Initiative report with the decision letter of January the 8th, 2021, which is core document CD 20.7, where the reporter in that instance set out that while there is effectively, they set out while there is a need, for renewable energy development and to tackle climate change, you still have to consider all the other matters related to resources, landscape, visual impact, etc. the balancing exercise remains in place.
I would, Ma'am, I would just add that decision is under challenge in the Court of Session at the moment on the very matter of the need case and the planning balance. Therefore, the applicant may wish to make some legal submissions on that in closings on the reliance that can be placed upon that particular decision.
Yes, thank you. I'm aware that you obviously included some of those papers in the last version of the core document list, so thank you for drawing that to my attention. That, I think, is item 2A taken care of. Sorry, Mr. Fraser, sorry.
I must confess, it's only something that's just occurred to me, and now I will make that confession. But just looking at the passage, I do wonder whether the fact that it's in the context of effectively the discussion as to whether there needs to be an inquiry is something that we should be bear in mind. And what I have to say has just floated across my mind is whether, when the reference is being made there to the needs case for the proposed varied development, where the reference is being made to the renewable energy need, which is what we're discussing, or whether reference is being made to why there was a proposal to vary, i.e. why it might have been being suggested there was a need to vary the development. And I have to say, just looking at the passage and in its context, I'm not sure that we can necessarily conclude which it is. I just throw that out now, and I admit it's not something I've even discussed with Mr. Bell because it's only just occurred to me, but it does seem to me that that's perhaps something that needs to be considered. I see Mr. Kelly might have an answer to that, but it seems to me perhaps something that should be considered.
May I respond, ma'am?
Yes, briefly, please.
Yes, I deal with it in paragraph 19 of my hearing statement. The Minister's comment was made in response to the objection by the John Muir Trust. And the John Muir Trust objection, which I think unfortunately is not an inquiry document, the John Muir Trust objection raised a whole series of issues under the concept of the need case, arguing from the perspective of targets, a whole range of things. There was no need for the variation at Gordon Bush. So the comment was made in response to a submission on need. So I hope that answers the point that Mr. Fraser has raised.
Thank you. I notice in the paragraph above there is a reference to that, as I say, without having the John Muir Trust letter, but it is the use of the phrase needs cases in the paragraph above as a concept raised by the John Muir Trust. So perhaps it is closer to what we're considering today. So I'll move on to 2B. That's a matter to do with whether or not the more recent statements to do with green recovery and the COVID-19 phase, the pandemic issues that have affected us all, and whether or not that has had an impact on either the published documents that make up the need case, or whether or not it changes the emphasis that should be given to it. And obviously my first question is probably for the applicant to kind of highlight if there is anything in recent publications that change the emphasis of the needs case.
Yeah, I think that last term you've used, ma'am, the emphasis, I think what we've seen in a lot of the documents referred to, and I'll just highlight a few of them, is the need to build back greener. There's reference to building back fairer, but also building back greener in terms of the recovery from the pandemic. And I would treat it fairly briefly. I think there's two levels it comes through. One is the UK government level. And in chapter 2 again of my hearing statement, I'll just signpost you to what I would say are the key references. The Committee on Climate Change report to UK Parliament, June 2020, that's CD 8.23. The key section is my paragraph 2.3.22. And what I'm pulling out there is that the reference to climate investment, helping to create jobs and stimulate economic recovery. Secondly, my paragraphs 2.3.23 to 27. Also, the UK government response to the Committee on Climate Change report, which is CD 8.25. My paragraph reference is 2.3.33. And then lastly, at the UK level, the white paper, CD 8.18, which references the green recovery and I reference that at my paragraph 2.3.50. So I would say at the UK level, those would be the key references. From the Scottish Government's perspective, the advisory group on the economic recovery is reported at CD 8.10, and that's my paragraph 2.4.44. There's then the report to the Climate Emergency Response Group, of that group, to the Scottish Government, CD 8.12, and my paragraph 2.4.49 is relevant. Then the Programme for Government, that's the Scottish Government, CD 8.13, which I reference at 2.4.58. And then lastly, the update to the Climate Change Plan in Scotland, and its title is Securing a Green Recovery on the Path to Net Zero, and that's CD 8.17. And my relevant paragraph starts at 2.4.61. So in terms of the need case, as we called it at the start, what I would say is that the benefits are not simply environmental and emissions related. The economic benefits, I would say, now have added importance and should attract greater weight than they would have done perhaps in the past for the reasons set out in those various documents. And I would finish with reference to the Chief Planner's letter published last month, which is CD 9.10. Now, that may not have been out before the hearing statements were exchanged. It may have been, but I think I reference it in my paragraph 6.5.3 that sets out that the planning system will have a critical role in the future economic and societal recovery. So I think all of that taken together, there's a clear, consistent message coming through of the need for and the benefits of a green recovery, not just to create jobs and investment, but to deal with the climate issue that remains ongoing.
Could I supplement my question just to see, have you seen any particular change in emphasis as to how we should balance that against other environmental considerations, such as the ones that are considered in this inquiry, such as landscape and visual ecology and ornithological matters?
No, I think that would be up to the decision maker in each case, depending on what is before them. It's not a matter, I would say, of deciding that less weight or protection is given to an environmental matter, but what is clear is that it's now open to a decision maker to take into account these new matters and decide what weight to place on them, as one would do in any planning determination where there are new matters coming into play that are material.
Thank you. Polly, just does the council have a view on that approach to the matter? Heinsohn, you're quiet.
Sorry, there we go. It's largely to agree with Mr. Bell's last statement there in response to your follow-up question, that it is up to the decision maker to come to a view on the weight to be attributed to matters that are clearly material in relation to those economic benefits and benefits in terms of renewable energy. But I think while there are those matters coming through, the documents that Mr. Bell referred to, it doesn't give any less weight to the matters that are in front of this inquiry in relation to, from the Highland Council's perspective, certainly visual impact, and it's for that balancing exercise to take forward.
Mr. Kelly, do you wish to contribute? No, he's signalling. That takes us to 2C and this concept of double counting. Mr. Heinsohn refers to it in his statement, and also Mr. Kelly uses the same phrase. We've kind of touched on it. Mr. Bell alluded to it as well in his first answers. But could you explain to me what you consider to be? I suppose it's a question for Mr. Heinsohn, for the applicant, for the council. Sorry, is what you consider to be the double counting concept and why ministers are to be cautioned against it occurring in their decision.
It's something to be aware of rather than maybe cautioned against. Obviously, in the consideration of an application under the policies of the Highland Wide Local Development Plan and National Planning Policy as well, through paragraph 169 of SPP, there is consideration of the benefits of renewable energy and whether that's in relation to renewable energy generation or the economic benefits. And it's consideration of that, which obviously is looking at the positives, but there's also the consideration under paragraph 29 of SPP in relation to 28 and 29 of SPP in relation to the presumption in favour of sustainable development. And it's making sure that if people are aware that we shouldn't be looking at the positives in relation to the balancing act under what we would do through the planning policies, and then the positives under the matters related to sustainable development as well.
Kelly, would you want to add to that explanation?
Just very briefly, I agree with what Mr. Heinsohn said. It's a note of caution, really. The general policy support for renewable energy generation is underpinned by a series of asserted benefits of renewable electricity generation. Therefore, when you come to consider in the balance the benefits of a particular scheme, your focus should be on the particular additional benefits of that scheme beyond the benefits that are already built into the supportive policy framework. So really, it's just a note of caution to try and avoid double counting of the same benefits.
Mr. Bell, do you have a response on that matter?
Yes, I do, ma'am. I mean, this is not unfamiliar. Mr. Kelly has advanced this proposition for several years, I think, at various inquiries, and I think it's an entirely flawed proposition. And I've not seen any decision maker, reporter or ministers give it any weight or reference in a decision. And I think the council has now, for some reason, picked up on this and is adopting Mr. Kelly's position. I think the danger in saying that SPP and NPF3 have all that you need and you don't need to place any additional weight on matters, whatever other documents say, is wrong. That's what the logical follow through of the position seems to be. And I think it's not so much a matter of double counting. I would suggest it's a matter of weight that we're coming back to. And the factors that we're giving weight to are generally ones that have always been in play, but it's a matter of giving more weight to those factors. And I think where it's helpful to perhaps further see how reporters dealt with this, not to copy it, but just to show how the matter has been handled, is in Paul's Hill 2. And just for ease of reference, in my hearing statement, I've quoted the reporter there at my paragraph 2.6.26. And what reporter Mr. Bowyer said was that, if I can read it, it's very brief, but just for those that don't have it before them, it says,
No, that's fine, carry on.
He says, I find the support this proposal can draw from SPP has been strengthened by the publication of subsequent policy and strategy documents, such as the onshore wind policy statement and the Scottish Energy Strategy. Very recent changes to legislation that commit Scotland to net zero carbon emissions by 2045 add some further support to the proposal, given the clear policy position that onshore wind energy is a positive contributor to the objective of lower carbon emissions. Further support can be drawn from the clear recognition by the Committee on Climate Change with the need for much greater progress on carbon emission reduction in the future, which has led to the declaration of a climate emergency. So the reporter starts off with the base position of SPP and NPF3. And that remains, of course, the planning framework that we are dealing with. Mr. Hinson's rightly said, paragraph 29 is important and it lists various considerations for us. But what the reporter was identifying is that further support can justifiably be given because of new factors and matters that are in play. And that goes to the matter of weight. So it's not double counting. It's, I would say, giving additional weight to considerations that are evolving since SPP came into force back in 2014.
Thank you, Mr. Bell. Does the councillor or Mr. Kelly want to come back on either of those points?
I might just come back if I can jump in before Mr. Heinsohn and say that, so that whilst I understand the point Mr. Bell's making, in our submission it's too absolute. I mean, the point he made himself is that obviously there are new documents since SPP and MPF3, and if you look at the statement of agreed matters, there's no dispute between the applicant and the Highland Council that they're relevant and matters to which weight can be given. But on the other hand, Mr. Bell must accept, or should accept in my view, that both SPP and MPF3 and indeed the Highland-wide Local Development Plan reflect energy policy at the time they were implemented. And it's the caution that Mr. Heinsohn urged, and it was only caution, was simply that one needs to be aware that that is the case and that the policy support for renewable energy is reflected in a number of places, and just to be aware of the potential for double counting. Not part of our case to suggest that, for instance, a recent policy statement in 2020 would be double count, should be ignored because of SPP, and that's certainly not what either Mr. Heinsohn, his witness in his hearing statement, or Highland Council elsewhere have suggested. So I don't think it's as absolute a position as Mr. Bell is making out. And frankly, I think on analysis, there's probably not a great deal of difference between him and Mr. Heinsohn.
Does anybody want to come back on that point? Oh, Mr. Fraser.
Sorry, ma'am. Yeah, I just stress, actually, it was interesting listening to Mr. Finley's answer there, and the point he made to you was that various policies such as SPP reflected energy policy at the time that they were implemented. Now, I think that the danger, because Mr. Finley's accepted that the later documents are A, material considerations, and B, weight can be given to them. They must then, we would suggest, because they are different to the energy policy that might have been in place at the time, for example, at SPP came out, they must affect the weight that then can be given to these various considerations, which I think essentially is the point that Mr. Bell is making, but I'm happy to hand back to Mr. Bell on that.
I think
Quite informative. Sorry.
I would say one final point on to emphasise why that's correct is SPP and NPF3 talk about the move to a low carbon society, and there's been a fundamental shift to net zero. That's net zero emissions, and that is entirely different to simply moving to a lower carbon position and that's where we were back in 2014. But the policy imperative is all centered around net zero, where we have the most challenging targets in the world. So that is a fundamental difference compared to the policy at the time of 2014.
Thank you. Can I just ask Ms. Hayward, are you happy that we've covered everything under item 2? Right, so we'll move on. It's coming up for 10:15, so we'll keep going for now. And to item 3 on the agenda, which is the constraints payments issue. We've already agreed to accept the new evidence from Mr. Kelly by email. But my question for Mr. Kelly is very specific. It's really just the relevance of the constraint payment information to Scottish ministers.
Thank you, ma'am. Given the scale of the money involved, I would be surprised if any member of the Royal Town Planning Institute thought it irrelevant. It is a clear factor in a net economic impact assessment. It is a clear cost on electricity consumers, and it is an escalating cost on electricity consumers. It reflects grid constraints, obviously, and the lack of investment in grid, and it probably also reflects not taking account of grid capacity when consenting wind farms. So it is a very real cost. It's an external environmental cost, and it should be factored into the net economic impact assessment in paragraph 169 of SPP. It's perhaps rather simplistic, but in discussing this with clients, I referenced the situation of, imagine you were considering a very large housing development rather than a wind farm, and you knew that the off-site infrastructure was highly constrained, resulting in costs to society. You wouldn't simply consider consenting the housing development and totally ignoring the off-site effects. But coming back to SPP, it talks in paragraph 169 about a net economic impact assessment, and this is a cost which should be factored into that, in my view.
Does the applicant want to come back on that point?
Thank you, ma'am. This is another line of argument that Mr. Kelly's advanced at several inquiries. And my view is that it's not relevant. It's not a relevant planning matter, and no weight should be afforded to it whatsoever. To start with SPP, paragraph 165 makes it clear that grid capacity should not be used as a reason to constrain the areas identified for wind farm development or decisions on individual applications. This exact line of argument was advanced at the Fallago Rig inquiry, which reporter Mr. Russell presided over, and the decision is before this inquiry, CD 20.10, 20.11. And in that inquiry report, at paragraph 3.108, the reporter concluded on the very similar evidence that Mr. Kelly had advanced. And that's page 55 of the, we don't need to go there, but I could read very briefly what the reporter said for everybody's convenience. He said, "I do not consider that the broad policy support for renewables is dependent on the availability at the time of determining the application of a favourable fiscal or subsidy regime for developers, nor does it depend on the existence or absence of a payment mechanism to deal with potential peaks and troughs in supply or demand, either nationally, locally, in relation to particular grid capacities. Now, the Scottish ministers in their decision letter, paragraph 6, said that amongst the various public representations, concerns were raised on a number of subjects, including landscape and visual impact, but also constraint payments. And the ministers went on, although the application was refused, they set out at page 7 of their decision that they agreed with the reporter's findings, reasoning and conclusions, and adopted them for the purposes of their own decision. Now, in that case, the ministers just disagreed with Mr. Russell on Schedule 9 matters, but they agreed with him on everything else, including how he approached the matter of constraint payments. Now, we could go on at some length here about the fact that constraints payments is part of national grid practice that was consulted on several years ago as part of what's called the connect and manage approach. And constraint payments are not just for wind. Sizewell B was paid many tens of millions last year to turn down, as were gas generators. But of course, Mr. Kelly hasn't referenced any other technologies that enjoy constraint payments. But in my view, it's not relevant to go there because of what SPP tells us, and indeed how the ministers have very clearly dealt with that in another very recent case. Thank you.
Does the council have a view on this matter?
We don't have a view on this matter, no.
Thank you. That takes us to item 4 on the agenda, which now deals with the planning policy that's embodied within excuse me, National Planning Framework 3 and Scottish Planning Policy, and also looks at the position statement on NPF 4, which have all been referred to in various statements. I'm really looking at the applicant in this case at first, and looking for an explanation of whether they think the position statement on NPF 4 affects the generally supportive position on renewable energy development that's already expressed in SPP and NPF 3, and also whether he's identified any change in the way that NPF 4 expects to treat these other environmental considerations that we've talked about: landscape, visual, ecology, ornithology, matters that are important to this inquiry too. So really looking at whether or not, just to what extent the position statement is taking policy in a new direction. Oh, Mr. Kelly, you're raising a question there.
Ma'am, I've just received a message from a client saying that the live feed has failed. I don't know whether you're able to check with Graham if there is an issue or not. Thank you. That was all, ma'am.
Graham, are you catching that discussion?
Elspeth, I can check because I'm in the office today, whereas Miss Cook is not in the office today. I can check with my colleagues in the office. If you give me a minute.
Ma'am, it's just come back on again. Sorry for that.
Well, yeah, no, that's fine. Thank you for letting us know. We do live a little bit detached from it for just now. So back to Mr. Bell and the question I was posing regarding how the position statement on NPF 4 takes either renewable energy policy or other policy positions on environmental matters into a new direction.
Yes, thank you. In my hearing statement at paragraph section 3.4, I deal with the position statement, and I think at the outset it's fair to acknowledge that the government's made it clear it's not new policy yet, but it's a direction of travel for policy. But one of the fundamental changes that is expected is the rebalancing of the planning system so that climate change is a guiding principle for all decisions. And it sets out on page 2 that we cannot afford to compromise on climate change if we are to meet our targets. and significant choices will have to be made. Now that is quite strong language indicating a changed approach. And in terms of key opportunities, page 3, there is reference to supporting renewable energy development. And importantly, in terms of outcomes, which is on page 5 of the statement, there is reference to the need to prioritise emissions reduction and the need for an urgent and radical shift in the spatial plan and policies, and the need to deliver infrastructure to reduce emissions. And all of that is driven to net zero. And that, as I was saying earlier, is a fundamental shift from what is in the current SPP and NPF3. I think in terms of some of the issues that we've got in play in wind farm cases, certainly in terms of national parks and national scenic areas, they're not issues here in this case, but they are, the government's made it clear that they don't expect change with that. But they have signposted that there could be change in relation to wildland, whereby there's a recognition of depopulation and the need to repopulate and stimulate the economy. So what that policy change will be, we've yet to see. But certainly what we can confidently see is that the net zero drive and the priority to be given to emissions reduction in the planning system rebalancing is front and centre of the policy document at the moment, recognising, of course, that it is a direction of travel at this time. Thank you.
Does the council want to come back on those matters?
Yeah, just very briefly. Yes, completely agree, as we've set out in the statement of agreed matters at paragraph 4.3.8, that there is that shift from the low carbon focus of NPF3 and SPP to the more ambitious net zero agenda for NPF4. But what NPF4 position statement also sets out is that, well, it doesn't implicitly imply anyway that there'd be any reduced protection for the environment as a result of that shift to the more ambitious net zero agenda.
Just one final point. I think what we've yet to see is the rebalancing of the planning system, and that I think Simon and I will wait with interest. What will that mean for matters of weight to be given to different considerations? We don't have that yet, and I think for onshore wind, the spatial framework is being reviewed, and we don't know what that will provide. The detail on that has been withheld at the moment, but where we're agreed certainly is that net zero underpins the whole approach.
Thank you, Mr. Kelly. Do you want to add anything there? No, thank you. Takes us to 4B, where we are looking at where, in terms of which parts of paragraph 29 of Scottish planning policy are really relevant to determining whether this is a sustainable development or not. Again, there's lots of, I think there's some agreement on the positive aspects of this, but I'm really looking for the council first to focus in on which part of this, these criteria in the paragraph that they're relying on in saying that the development is not sustainable.
I think when it comes to the preceding paragraph 28, where it sets out that the planning system should support economically, environmentally and socially sustainable places by enabling development that balances those costs and benefits over the longer term. The council's position is that the development is not environmentally sustainable because of the significant adverse visual impact of the the development, which in our view is significantly leads to the development being significantly detrimental overall. So that then falls under. So I'm just counting down the bullet points in paragraph 29. So it would fall under the, well, third from bottom bullet point in paragraph 29, where we have concern, and we would give that significant weight in assessing it against the points in paragraph 29 in those principles there.
So I'm just going to check I've got the right one then. So that would be protecting, enhancing and promoting access to natural heritage, including green infrastructure, landscape and the wider environment. Is that the correct one?
Sorry, I've got that completely wrong in terms of it. Sorry, I've picked up the landscape word in that and just skim read there. Sorry.
Maybe number 9, Simon, for you.
Yes, it would be. Yeah, it's the ninth one. I would suggest. Thank you, David.
So that is having regard to the principle of sustainable land use.
Yes, yeah.
Thank you. Now, does the applicant want to come back on that in terms of Mr. Heinsohn's statement there?
Yeah, I think there's a parallel in looking at these policy principles to policy 67 that we'll come on to. And the way we're approaching policy 67 that the council follows is that if you fail or you're judged detrimental on one of the criterion, you don't fail overall. You need to look at the picture in the round against the policy. And I think it's the same with these policy principles. I've set out in my hearing statement on page 42 how the proposed development would relate to those policy principles. And I've set out that my conclusion that it does accord with them in a positive way and a satisfactory way. And my view is that one needs to look overall. So if the council's right is justified in having its own concerns on visual impact, that is one of certainly 11 considerations. So if we take the same way we approach policy 67 and say, well, in the round, in terms of is this sustainable development given its contribution and consistency with the various principles, then my conclusion is that it would be. And therefore it should enjoy that presumption, underpinned also by the position that it's Group 3 in SPP, where there is an expectation that wind farms will be acceptable in those areas, subject, of course, to detailed consideration of development management matters.
Does Mr. Kelly want to come back on that? Does the council have a response to that at all, Mr. Heinsohn?
Just in relation to, I suppose, the group 3 issue that Mr. Bell just raised, in terms of the spatial framework, it's, so I'm just going to the relevant page for that. What group 3 says, as Mr. Bell said, there has to be detailed consideration of those, but group 3 areas are simply areas where there are no group 1 or group 2 features. And then those matters that are left over, as set out in paragraph 169 of SPP, paragraph 29, and obviously paragraph policy 67 of the Highland Wide Plan, they need to be considered in detail and as Mr. Bell set out, it's something that has to be considered overall, not just one matter in isolation.
Ellie, do you want to come in on this point?
I think just to reinforce the point, Mr. Hinton's right, it's detailed consideration, but it does say in these areas, wind farms are likely to be acceptable. That is the wording.
Mr. Kelly, no, nothing to add. Now that takes us to item 4C. I'm wondering if I take this item, we might have a short break as we'll finish item 4. So this is the issue of the 3 paragraphs that make reference to wildland in Scottish Planning Policy, 169, 200 and 215. And I'm just looking if to see if the applicant can really pinpoint and just explain why there is a different emphasis in these paragraphs and how that should be reflected in the assessment of any wildland matters.
Yeah, thank you. I would, paragraph 169 of SPP lists the various considerations, and bullet number 6 is landscape and visual impacts, including effect on wildland. So that's the first reference, and that is what I would say is the key one for this case. But SPP doesn't give us any particular weighting on that either. It's one of a number of considerations listed there. The other 2 references in SPP is paragraph 200, which is sets out that wildland character displayed in some of Scotland's remoter upland areas, and that it's sensitive to any form of intrusive human activity and may have little or no capacity to accept new development. And it sets out that plans should identify and safeguard areas of wildland as identified in the mapping. So it's very much about direction to planning authorities, about plan making, and sets out the approach insofar as it's a group 2 interest. The other paragraph is 215, which is specific to development within wildland. So that isn't applicable in this case. So paragraph 200 and 215 deal with wildland itself rather than development outside of wildland. And the focus should be on paragraph 169. Now, what we're not saying is that this suggests that if you're outside of wildland, then the impacts on it can be irrelevant. They are, of course, a consideration, but there is no embargo on development that can be seen from the mapped interest, and it's simply one of a number of considerations, and it has been taken into account in this case.
I'm just wondering, obviously in the wording about taking, there's wording I think in one of these paragraphs, oh yes, it's in 215, that significant effects on the quality of the areas can be overcome. Now, obviously that's referring to, in that case, developments in wildland area. But Mr. Bell, do you think that considering the qualities would still be relevant in the context of 169, that still would be a relevant matter for the decision maker?
I think the qualities would be, but that specific test in 215 that's applicable to group 2, because we see it again in the group 2 table, wouldn't be. So one wouldn't apply that test of having to overcome substantially. That's only for development within wildland.
Just so I'm correct, so the issue of overcoming any significant effects wouldn't be relevant, but perhaps as Mr. Mason's evidence does, he's still considering the qualities.
Absolutely, yes. That's very fair. Yeah.
Mr. Kelly, do you wish to come in on that point?
Yes, ma'am. Largely, I agree with what Mr. Bell has said, but for me, the starting point is Table 1, spatial frameworks, and the wild land areas are areas to be afforded significant protection. And in my view, that significant protection to which they are to be afforded applies in respect of developments both within and out with the wildland areas, as set out in Dr. Carver's evidence the other day. But otherwise, strictly speaking, for this case, as Mr. Bell said, you're applying provision in paragraph 169. My only view is on paragraph 215, which I agree applies to development within areas, is it gives you a clear hint as to the sorts of considerations that you might have regard to when giving weight, or any weight you would choose, to significant protection. Those words of significant protection from Table 1 spatial frameworks is the only point I would want to add in, ma'am.
Yes, thank you. Mr. Bell, do you want to come back on that?
Just briefly, I think what the ministers have said through SPP is that the particular concern they have is development in wildland. That's why we get paragraph 215 and the test of overcoming for group 2 locations. So that it's not an equal approach to development outside or inside wildland. It's their particular concern is if you're in wildland, and it's not if you're out with. Not to say it's irrelevant, but it's clearly less of a concern given the way the policy test is set out, applying to group 2.
Council have a view on this? I know you don't have a particular objection on wildland matters.
Just largely agree with Mr. Bell and Mr. Kelly in these matters. I think when it comes to development of in areas out with wildland areas, it's consideration of the particular wording of the qualities of those wildland areas when you're coming to a view on those, because some of the qualities of the wildland area do extend to areas out with the wildland area. And for example, there's some wildland areas where the qualities relate to intervisibility between wildland areas as well. And those matters do need to be given consideration.
Thank you. Ms. Day, would you have anything to add on section 4? Do you have any queries? No. Well, I'm going to take a short break. That's us at 10:40. So we'll just take a break until 10:50, and we'll come back and finish off these questions from the hearing agenda. So I'll just turn off the mics and things just now and have a 10-minute break. Thank you. Okay, I think that's everybody back. Mr. Kelly, oh, there's Mr. Kelly's video on now. We were at item 5 in the agenda, and it takes us into discussions on the Highland-wide Local Development Plan, CD10-1. And the first point I've raised is really about the wider process of the handling of development plan matters in a Section 36 case. You'll see Mr. Kelly's position is that he thinks that we should first consider the development plan and then material considerations. And I don't know if there's anything significant in this or not, but I'm wondering, does the council or the applicant have a view on whether in 36 cases you would apply that same process? For maybe the applicant first.
Thank you. Yes, I think it's a very different approach that's needed. And I think the first point is, I think it's common ground amongst us that there's no primacy of the development plan. In an Electricity Act case, there's no prescribed considerations as you would get in a planning application determination under Section 37(2) of the 97 Act, where you need to refer to the development plan. And in fact, the 1989 Act doesn't refer to the development plan at all. There is no scope for applying Section 25 of the 97 Act. And there's case law to that effect. We don't need to go there, but it's the William Grant case, which is CD 20.3. I think the council's in agreement with that approach. So the way I would suggest it's ordered is that certainly energy policy, the developments coming forward in that context, then national planning policy, and then the development plan, probably in that order. So it is a consideration, but it's not a Section 25 approach, test type approach.
Is the council broadly in agreement with that summary?
Yes, broadly in agreement with that, yes.
Would Mr. Kelly like to come back on that at all?
Just very briefly, ma'am. I mean, remembering the timing and purpose of the 89 Act, it was not an act that was set up or designed to enable the decision makers to assess whether or not to grant consent to wind farms in remote locations. It was an act about the privatisation of the Electricity Act and the connection of large thermal generating stations to the grid. I can confirm I'm certainly not trying to import a Section 25 test here. My approach is purely a pragmatic one in that it tends to be the development plan that sets out all of the considerations that you would want to take account of, along with paragraph 169 of SPP. So really it is a pragmatic approach to assessing an application rather than a legalistic approach.
Mr. Bell, would you want to come back on that? Are you happy with that response?
Yes, that's fine.
Thank you. So that takes us to item B, and that's about the particular Highland-wide Local Plan Policy 28 on sustainable development. The council refers to that in their reason for objection, but I was looking for a little bit more of an explanation. Obviously, having looked at policy 28, I don't know if you've got it in front of you. It's in, obviously, it's digital page 79 of core document 10.1. It's quite a lengthy set of policy criteria, not all of which are aimed at renewable energy projects. So I'm really looking to focus in on which bit of policy 28 I should be considering in our report of findings. The council first.
Thank you. We referred to policy 28 in relation to, again, it's a similar policy in a way to policy 67. Policy 67 obviously being the primary policy against which we determine renewable energy developments. But we refer to policy 28 as it considers those other matters as well, in relation to the extent to which they'll be assessed, proposals will be assessed against. And again, there is that presumption in favour of sustainable development built in through this policy. However, it's in particular in relation to this development, it's one of the principles set out there, and it is on. So I've got paper copy, and it's on page 78 of the paper copy. I should probably go digital because my paper copy is literally falling apart. I've had it for so long, but it's on. It's the fourth bullet point down on the page 78 of the paper copy, which starts with demonstrate sensitive siting and high quality design in keeping with local character and historic and natural environment, and making use of appropriate materials. That's the area where as Ms. Pearson's evidence set out earlier in the week, we don't believe that the development does demonstrate sensitive siting and high quality design in relation to wind farm developments, but we do appreciate that policy 67 is more applicable when considering matters of visual impact.
Does Mr. Bell want to come back on that point?
I think this is an example where double counting would be a real concern, because policy 67, I think, covers all the relevant considerations. And when one looks at this policy in the round, it's a catch-all primarily for typical built developments, I think. So whilst what Mr. Hinson says in terms of those considerations, they are relevant, I think policy 67 gives you what you need, and you don't need to go and pay much attention to this particular policy.
Mr. Kelly, do you have a view on this? No, thank you. And that takes us to policy 57. Now, this raises some wildland area matters again. You'll see from my brief summary there, excuse me, Mr. Hinson's statement is confirming that policy 57 is not relevant. It's essentially referring to out-of-date wildland mapping approach that the council no longer follows. But I'm really looking to see if the council can direct me to any part of policy 67 or elsewhere in the plan that would perhaps be relevant in the broader sense to wildland matters.
Okay, so with that said, in relation to other policies within the plan, looking where you would look at wildland matters, it would be under policy 67, where you're looking at visual impact and impact on landscape character of the surrounding area, under the third of the criteria within that policy.
Well, would you agree that that is a place where any matters of wildland should be considered?
I think that's very fair. And what I would say, though, is we've got to remember that that development plan was adopted in 2012, so 2 years before the wildland policy came out. And as we've discussed earlier, SPP already gives us quite clear guidance on dealing with wildland as a general landscape and visual matter, at paragraph 169. So I don't think we need to go searching for another LDP policy from a 2012 plan to try and salvage some, historic reference that might fit. I think SPP gives us enough with policy 67, as Mr. Hinson said. That would be fine.
Mr. Kelly, do you have any views on this point? No, thank you. And that takes us to policy 67 at part 5D of the agenda, where we're looking at policy 67 and possibly the onshore wind energy supplementary guidance. I'm looking really for the council just to focus in on where the main tensions are within policy 67. And I think, bearing in mind the evidence that was led through Mrs. Pearson's, well, actually through the cross-examination of Mrs. Pearson's evidence, we might need to have another look at the SG criteria in light of that. So we'll concentrate on policy 67 first. And if you could just kind of point me to the bits that you are most concerned about. Thank you.
Okay, so it would again be the third bullet point related to visual impact in that policy, and then the fourth one as well in relation to amenity at sensitive locations. And we've also highlighted tourism and recreational interests there, which would be applicable for users of the path network, which Mrs. Pearson highlighted, and also from the A36 as well, which is the views from the north into the site itself. And it was in undertaking the balancing approach of the policy that it was considered that the effects on those considerations outweighed the benefits of the scheme.
Mr. Bell, do you have a view on that interpretation?
Yes, thank you. I think that the policy is very clear in the preamble text before one goes into the various bullets, where it says that the council will support proposals where it's satisfied that they're located and sited such that they will not be significantly detrimental overall. So that's similar to what we were talking about in the SPP principles context of taking a view overall of all the various considerations. And then it goes on to say that having regard to any significant effects on the following. So one takes account of significant effects on the different criteria listed, but then a judgment is needed overall as to whether the development would be significantly detrimental, taking into account the benefits. And I've set out my approach to that on page 54 of my hearing statement.
Mr. Kelly, any views on that? No, that's fine, thank you. So that might take us then to look at the criteria that was informing. Obviously, the reason for objecting makes reference to non-compliance with the onshore energy policy. And there was some questioning about the particular criteria. I can find the right page in the document. So in digital page, they start at digital page 21. I was wondering, Mr. Hyson, if you would summarise whether you're in agreement with, as a result of Mrs. Pearson's evidence, whether you could run through these criteria and confirm where you feel there is still remaining tension with the thresholds and requirements.
I can try my best. I can't recall everything that Mrs. Pearson was cross-examined on, but I will try my best. And sorry, I'll just bring up Mrs. Pearson's report on handling for reference as well, and which I believe is CD 2.1. Okay. So in terms of criterion 1, So in terms of criterion 1, there is considered to be a tension there for those people who are travelling through the area, given that the development would appear to be visually prominent in the majority of the views from settlements and when viewed from the A36. In terms of criterion 2, it is considered that the criterion is met, or the threshold in the criterion is met, sorry, but there are localized areas of conflict. Criterion 3, it's considered that the criterion is met there as it doesn't diminish the presence of any landmark or disrupted setting. Mrs. Pearson, when she was cross-examined on criterion 4 and criterion 5 together, and I recall Mr. Fraser separated those out for the purposes of cross-examination. And what Mrs. Pearson's evidence was, I can't quite recall on both of those. So I could just set out what was in the report on handling, where she set out that both of the criterion would not be met in terms of impact from those recreational routes, and again it would be the A36 as well in terms of transport routes. And then in terms of criterion 6, the conflict lies through the pattern of development in the area, as it doesn't sit well with the existing scale of wind energy development within the area, in terms of overall tip height and proportions of the wind energy development. And criterion 7, she set out that the development doesn't meet the criteria by virtue of failing to relate well to the existing landscape. We usually do take criterion 7 and 9 together, because there is an interrelationship between those two criterion. And then in terms of criterion 8, 8 and 10, Ms. Pearson took those both together in her report on handling, and she said that the criterion would not be met, as set out in the landscape and visual impact assessment. It's considered that the landscape character type will be compromised as a result of the development.
Gail, do you wish to follow up on that?
In terms of the evidence exchange, there'll be a note of that, as Mr. Hinson summarised. But I think important to note that Mrs. Pearson also said that this was a background to the assessment, and is not referred to at all in her appraisal. That's the sort of note I have of that. And I think the council in other cases has certainly made it clear that it's not viewed as a development management test checklist, if you like, that it's comply or not comply, and that it was used as a guide to inform judgment in policy 67. I think in my hearing statement, I cross-refer to Mr. Mason's appraisal. So you have the applicant's position on the criteria set out in Mr. Mason's evidence. I think there is reference in Limekiln as well, which is CD 2026, where the reporter said on page 10 of that inquiry report that whilst of relevance, the supplementary guidance doesn't contain any specific requirement beyond those established by Policy 67. And he said, paragraph 940, therefore a forensic assessment of the proposal using the SG would offer little value to our consideration of the scheme's merits. So I think it's just placing it in context against Policy 67.
Thank you for those quotes. That's very helpful. But it does give me a difficulty in that it's specifically listed in the reason for objecting. Hence, I'm trying to establish how the council has approached it. Obviously, I noticed that Mrs. Pearson said it was a background information or assessment process that was assisting in Policy 67, but it is listed in its own right in the objection. So maybe Mr. Heinsohn can clarify that in a bit more detail.
Ma'am, perhaps if I can jump in first and assist. It is referenced in the reason for objection, and in our submission that's correct. But Mr. Bell is also right that Highland Council has consistently made it clear that it adds nothing in terms of a further policy test to that which is contained in the local development plan. So that looked at a simplistic level, if you fail to comply with the local development plan, you will also fail to comply with the supplementary guidance, and the contrary would also be true. But we're absolutely clear, and Mr. Bell is correct, that it doesn't add or provide any new tests. The criterion to which reference is made, and I don't think the criterion are referred to in the reason for objection, provide a checklist of factors to consider, some of which may be more or less relevant to any particular application. And in this application, as one knows, Highland Council doesn't contend that this is not a suitable location in general terms for a commercial scale wind farm. Now that would be very different from other applications, and that will have a different implication for the application of the criteria. So in various circumstances, some of the criteria will be more relevant than others, and one might think in this case criterion 6 might be more relevant than some of the others for that very reason. And Mr. Bell is quite right that Mrs. Pearson said it's part of the background to the assessment. She didn't refer it to it in her appraisal, and the reason perhaps she didn't refer it to it particularly in her appraisal, is that I think as Mr. Mason accurately identified, that the issues between the parties are because of the acceptance I just said of the in-principle acceptance, are fairly well defined in this case. And so whilst it is relevant, properly mentioned in the reason for objection, I don't wish to overstate its importance in terms of the decision-making process you have to undertake and advise the ministers on. It doesn't add anything further, and in this case it might be considered to be of less importance than it might be in other cases. And whilst Mr. Bell has referred, I think, to Limekilns, where the reporters said that they didn't feel it would be of assistance to go through the criterion, and they may well have been right in that case. There are other cases where other reporters have felt it has assisted them. It's a matter of individual taste, if one likes. But hopefully that puts our position on the guidance clearly. It doesn't provide any further policy tests. It doesn't purport to. It simply reflects what's in Policy 67, and that's why it is referred to in the reason for objection.
That's clear. Does the applicant wish to come back on that at all?
No, thank you.
No.
Can I just flag one matter, ma'am?
Oh yes, sir.
I have to say I'm not convinced that Mr. Heinsohn's summary of the criteria quite matched Mrs. Pearson's evidence, but that's a matter I'll make submissions on. But I didn't want it to sort of pass without. I didn't want my silence to be seen as consent, if it might be that way.
Can I say I'm perhaps in rare agreement with Malone and Friend, and Mr. Heinsohn shouldn't take it as a criticism, but he did make some progress in, shall I say, refining the criterion which were in issue between the parties in his cross-examination, and that's not in dispute between us. And in fairness to Mr. Heinsohn, he did say that he couldn't recall all the cross-examination, and there will be a note of that. And I've no doubt that both of us will cover that in our closing submissions.
Thank you. The reason for raising it in the policy hearing was that I was conscious that there had been an element of change in the way certain of these criteria had been assessed as a result of the cross-examination. So that takes us to just double check. Yeah, 5E, and it's a particular. Obviously, I'm not expecting to spend long on this, but Mr. Kelly tells me there's a specific tension in the LDP policy paragraph. Well, not the policy, the supporting text at 2218 that might make it difficult to apply policy 67 appropriately, and I just wanted to get Mr. Kelly to explain that perhaps first in more detail, and then we can maybe take comments from the other parties.
Thank you, ma'am. It's not a huge point. It's really part of history. I mean, when I read paragraph 22.1.8, maybe I don't know whoever has it in front of them, but if I read it out very quickly, the relative significance of any particular consideration listed in policy 67 in the decision-making process may vary with and depend upon the type and scale of scheme proposed, and the appropriate weight to be applied will be determined having regard to the circumstances of the particular proposal and with reference to the development plan as a whole and any material considerations. Sounds like a bit of script from Yes Minister, I think. The policy, there's a history here. The policy as written, ma'am, was not Highland Council's policy. The policy and the preamble text as you have here was written by the reporter who took the examination into the local development plan. And at the time when we saw the proposed changes to the introductory text and policy, both Mr. Bell and I made submissions that there needed to be oral evidence heard to consider how the policy would then all sit together with the preamble text. That didn't take place. So my general point is taking that and policy 67 together, that paragraph in policy 67 together, I find it quite a challenging policy to apply, because you don't get any guidance as to any criteria of acceptability or otherwise under any of the bullet points. You don't get any guidance as to whether factors carry greater weight than other factors or not. And this significantly detrimental overall is a very vague expression. I mean, to comply with the policy, do you have to tick all the points? To be in breach of the policy, do you have to have a negative tick at all of the points? I just don't know. I find it a difficult policy to apply having regard to 22.1.8. But as you will have seen, ma'am, from the hearing statements, nonetheless, we do all try to apply it. And maybe it's just my kind of old-fashioned self looking for, hopefully in the future, a crisper and clearer wording of policy. Thank you, ma'am.
Mr. Heinsohn, do you wish to give me any further clarity on any difficulties that I might face with that particular terminology?
I think from our point of view, obviously there was significant history to this one. It was with Highland Wide Local Development Plan, there was only two hearing oral sessions on policy matters at the examination. This, as Mr. Kelly set out, wasn't one of them. And in relation to paragraph 22.1.8, I think that's really just trying to highlight that there will be different scales of development, and therefore the significant impacts arising out of those and the significant benefits arising out of those different scales of development will vary on a case-by-case basis, and the decision maker has to take that into account, given the scale of development, and then balance the impacts as to whether the development is able to be supported or not, in relation to the criteria or the issues set out in policy 67 itself. And we do obviously have the onshore wind energy supplementary guidance, which we were just discussing, and that is there to give that level of guidance on each one of the matters set out in policy 67. But it doesn't give an absolute reason, absolute point as to when things will be acceptable, because you can only do that on a case-by-case basis.
Mr. Bell, do you wish to add anything to that?
Just briefly, I think we have to deal with the policy in the preamble text as it is before us, and decision makers have not found it difficult to apply it, and its interpretation has never been challenged legally. It stood the test of time fairly well, I think, this policy, and it seems to me a sensible, workable approach. There may, as Mr. Kelly says, be different ways of phrasing it, but it's been found to be workable, and in all the various decisions issued by reporters and ministers, there's not been any problems identified with the workability of the policy, such that very limited weight has been placed upon it.
Thank you, that's helpful. Let's clarify that. Agenda. That was my last question on the LDP provisions. Ms. Hayward, do you have anything you want to add into that? No. So that takes us to any other matters, and that's this part on the control of woodland removal policy. It's slightly overtaken by events because obviously there's been a movement on the terms of the proposed condition that was going to deal with compensatory planting. But I feel it might still be useful if Mr. Heinsohn can draw to and just conclude in the hearing evidence where he sees there are relevant guidance from either the government policy or the SG about how compensatory planting should be treated in the Minister's decision.
Okay, so from Highland Council's perspective, when trees are removed, not for wider public benefit, obviously the control of woodland removal policy will apply. Our approach to the control of woodland removal policy over the years has been to seek any compensatory planting within the Highland Council area, rather than necessarily Scotland-wide, which is set out in the Scottish Government policy. Our reason for that is to ensure that biodiversity and economic benefits are retained within the Highland Council area from forestry operations. And in relation specifically to wind farm development, what we generally see is a site being clear felled to start with and then replanted. Therefore, we seek to ensure that appropriate replanting is brought forward in relation to current practice, or current good practice, sorry, and also to ensure that there is a long-term forest management plan which is in place for any replanting or compensatory planting schemes that are brought forward.
And so an extra question is, so you would be quite happy that these matters can be deferred to a condition stage and needn't be a documented proposal within the environmental information?
Yeah, we're generally content with that as an approach. The wording that we have now agreed with the applicant adds some further clarity to the condition, which is what we feel that we would need to have so that it would accord with the control of woodland removal policy. So essentially, we've got certainty on where on how it's going to be delivered, how it's going to be maintained, etc.
Mr. Bell, do you have a view on the relevance of the policy documents?
No, nothing in any great detail, just insofar as it will relate to the condition and the way that is framed, and that will be for the session coming up. And Mr. McGovern will be dealing with that and may be able to add some further detail, but nothing I would add to that Mr. Hinson set out.
Thank you. I just wanted to take the opportunity of using the policy hearing to introduce it as evidence in the round, so that it forms part of the wider core document list. That's all my questions. Ms. Hayward, do you have anything you would want to add in? I'm considering, obviously, we should just be bringing this hearing session to a close, apart from our procedural matters that are to follow. Is there any other burning policy matters that you feel I've overlooked or that you would wish to express just now before we finish? No, nobody wanting to add anything. So effectively that's hearing session 2 closed, but we'll keep going and slot into that an additional item on the agenda, which is to do with primarily closing submissions and the arrangements for that. My preference would be to consider a period of 10 working days for the Council and Wildland Limited to submit their closing submissions, which would take us up to the 14th of May. It's a Friday, as today, and then to accommodate a further week thereafter for the applicant and taking us up to the 21st of May. Obviously, I have no idea what other people's commitments are and holidays and other professional business. So really looking for a view from the parties on that proposal.
Well, the Highland Council's submissions would be ready by this time next week. So, but other people may not be in the same position, but certainly, and I have no observations on the time, length of time known from Mr. Fraser is given to respond.
Mr. Kelly, would you manage to speak with me?
There'll be some difficulties, ma'am. I have 2 applications to address next week, and then I'm on holiday for a full week, and I actually have another pre-inquiry meeting to attend virtually during my holiday, so I'm giving up part of it already. I would prefer either the end of the following week or the middle of the following week. It's just that I am away for a full week beginning Friday the 7th of May. So I would ask for the 19th or the 21st of May, and I have no view at all on the additional time for the applicants to respond. Quite relaxed about that aspect.
Pushed that initial stage quite a bit into May. I'm trying to keep the momentum going on this proposal. Is there any possibility at all of you meeting the 14th of May? Oh, Ms. Hayward, do you want to come in on that?
Could I suggest the council puts their closing submissions in earlier? Mr. Kelly gives his for the 19th of May, and then would that give you, Mr. Fraser, enough time by the 21st of May?
I'm sorry, ma'am. No, I have to say, I think that would be pushing it, quite frankly, if it was the 19th of May.
Sorry, I can't hear what you're saying, Mr. Fraser.
I'm sorry, ma'am. No, I think that would create difficulties for me, I'm afraid, if I were only receiving those submissions on the 19th to be providing my final submissions by the 21st of May. I think I would look for a little bit longer than that.
Mr. Kelly? Oh, you've gone quiet, Mr. Kelly. I think you pressed the wrong button.
Can you hear me now, ma'am?
Yes.
Okay. I'm actually back from holiday on Friday the 14th. I would be happy working that weekend. If it helps Mr. Fraser, I could commit to submitting the closing submissions on Monday the 17th.
I think if I could have them by then yes, I think the 21st of May would still be fine. Thank you very much.
Well, that looks to be reasonable. I think we're fitting in with everybody's commitments there and allowing sufficient time for the Mr. Fraser to pick up any points that comes through that. So we'll just confirm that the council will aim to submit theirs by Friday, the 7th of May. Mr. Kelly will look to deliver by the end of Monday, the 17th of May. And then Mr. Fraser's comments by the end of play on Friday, the 21st of May. And that will be our confirmed position. Is there anything else in terms of further procedure? I'm not aware of anything outstanding, but please keep me right on this if there's any other procedural matters still to be addressed. Ms. Haywood?
Just to remind people, Mr. Fraser, I think Mr. Mason and the council were going to get together to talk about where we look at a turbine that's got a light in the dark area.
I'm not sure whether Mr. Mason's managed to take matters any further with the council, but certainly we've looked into it on our side, ma'am. And I'm afraid we haven't been able to find one we think would assist. I think the difficulty is finding one that has the same properties as are proposed here, i.e. the directional properties, and also that it reduces in intensity when visibility is good. And that's why I'm afraid, whilst we've looked at lots of different other locations, our concern is that it probably would give you a false impression. I think you'd certainly have to be very careful about looking at them, because obviously we can tell you that particular light has a particular luminance, but it's not what's being proposed here is the difficulty, I think. So I think we would caution against assuming that looking at another light is the same as what's being proposed here. I think that's the difficulty we have, I'm afraid, ma'am.
Sorry, could I just clarify then that Mr. Mason did refer to the Crystal Rig turbine,
yeah,
which I have seen. Miss Cook hasn't seen. Is that light what you're proposing here?
I think that was the only one that we could identify that we thought that might be closest to what's proposed here, so to speak. Now, I think Mr. McGovern's nodding. Mr. McGovern can chip in if it helps at all. I think because obviously this has been going on behind the scenes slightly whilst I've been busy dealing with other matters. But that's certainly my understanding of where we've got to.
Okay, the only thing is obviously for our plans, we do hope to do another visit to the area in the coming months or weeks, I should say. So knowing as soon as possible if there's a preferred wind farm that you want us to view, really the earlier the better. So perhaps I could suggest that we get confirmation by the end of next week, which is the best example you would want us to look at and what its particular characteristics are in terms of the technology used, and we can make a judgment as to whether or not it would be a useful visit for us to incorporate with our further inspections. Is that acceptable?
No, I'm sure that can be done. I think I see Mr. McGovern's making a note as we speak.
Well, I think that brings that session to a close. I think obviously we're losing some of the participants now, so obviously just want to thank everybody for their efforts. Mr. Kelly, I think, is leaving us at this point, possibly Mr. Bell. So just really want to thank you all for your efforts in making a virtual inquiry and hearing session work quite smoothly. I think we've managed to get through this with a minimum of technological problems. It's allowed a very small but important part of this government business to continue, and we're very grateful for that. And hopefully we'll meet in more convivial surroundings the next time the inquiry or hearing session. So I'll say farewell to those that are leaving us. We'll take a break. That's 11:34. Slightly longer break. It's given me a wee bit of time to sort out the different core documents. Mr. Bell, sorry, you were waving your hand. Are you just saying goodbye?
Thank you very much. I'm going to sign off, but I'll go onto the webcast and view it that way.
Okay, thank you.
Same for me, ma'am. Can I thank you on my part and part of my clients? And again, I'll sign off and go on to the webcast as well. Thank you, ma'am.
I'm just trying to set a time so it will come back, say 11:50, and we'll see if we can crack the second hearing session before a reasonable lunchtime, and that would bring our business to an end for today. So thank you very much. We'll see those who are hanging around. We'll see you in about 15 minutes. Okay, thank you. Graham, that's 11:50 if you're able to switch us back on. Thank you, that's great. Do we have any changes in the people attending the second hearing?
Mr. McGovern's going to lead essentially on this, but I also have with me effectively my client, so it's Ellery Davis who's helping us out on cases, any matters.
Thank you very much. I'll do a brief introduction, obviously, just for the purposes of the webcast. So this is now starting hearing session 2 on the proposed conditions associated with this proposed wind farm development. For the purposes of the people watching the webcast, I want to highlight that this discussion on conditions should not be construed as indicating any particular outcome for these proposals at this stage. In formulating our report to ministers, we're expected to present a set of conditions that may be required in the event that a favourable decision is made on the scheme. The hearing is intended to address any areas of dispute between the council and the applicant, and also allows us the chance to seek clarification on the wording or requirements where we think that's necessary. There's a separate agenda for this session. Does everyone have a copy? I'm assuming so. Yes. And we got a new set of agreed conditions that were issued the 23rd of April. I'm assuming everybody has those as well. And in light of that, I might reduce the discussion that we have on items 4, 12, 16 and 30, but we'll deal with that as we come across those items. As before, I have identified a few core documents that might be useful in this session, so I'll just read them out. 3413, the SEPA consultation response from 2019. 76, which is the extracts from the Town and Country Planning Act that were added recently. 13.1, which is the Circular 4 of 98 on conditions. 13.2, which are referred to as the model conditions on wind farm developments. 14.4, which is health and safety advice on high voltage equipment. 18.1, which is the applicant's hearing statement. 18.3, which is the draft conditions as amended. And 20.27, which is the Strathy South Minister's decision. Does anybody have any procedural matters they want to raise before we start the discussions? No, that's fine, we'll crack on. So the first item is 2, and it was relating to the direction under section 58.2 of the Town and Country Planning Scotland Act. Now that direction is about adjusting the time period for the commencement of development from that which would normally apply. And it's given us a little bit of head scratching, I'm afraid. I don't think there's any, you'll maybe see from the points I raised. But to start with that, could the applicant probably just give us a brief description as to why this one needs longer than what would normally be considered the 3-year period that the model conditions start from?
Certainly, ma'am. I think our starting point would be that actually 5 years is normal, entirely normal in the context of development consented under Section 36 of the Electricity Act. I know reporters are keen to keep the session brief, so I won't take you through the long list of other Section 36 consent decisions, but I would suggest you could perhaps pick any one of those Section 36 decisions at random, and you would find that a 5-year period has been applied to that, and the reason and the approach of the ministers to that is set out in paragraph 3.2 of our hearing statement, that they recognise that projects of this scale and complexity require a 5-year period typically. So it would be the reverse of the proposition you put to me. It would be unusual, I would suggest, to have a shorter than 5-year period for a scheme of this nature, and in fact, where there have been exceptions to the rule, it's been in recent times where the ministers have given applicants 6 years rather than 5 years, and you can see that if you look at the Windy Standard 3 decision, Galt Clay, Crystal Rig, Paul's Hill 2. I think you have the CD references for all of those decisions from the earlier session this morning, so I won't go through them all.
No, that's perfect. I was really just wanting to get a little bit of context for the need for the direction. but it does take us to the legal question of how best to advise the ministers, taking into account section 58(4) of the Act, as it refers to time-limited deemed planning permissions, and how best we set that out for ministers if we have in fact been perhaps misusing the direction. I'm a bit worried about that. So I'm looking for a bit of guidance from the solicitors on that matter.
You raise a very interesting question, and it's one in which I've had discussions with the Energy Consent Unit, whose own view on this seems to have changed depending on who you speak to. If you look at, I think probably the majority of decisions that the Scottish ministers have issued, they do tend to attach a direction made under section 58. However, you rightly draw attention to subsection 4 of section 58, which does provide exceptions to section 58, and one of those exceptions is a time-limited permission. So I can well see why you could take the view that in the context of a wind farm, and indeed in the context of the proposed conditions for Strathy Wood, which do require decommissioning and discontinuance of use, why you might take the view that this is a time-limited permission, which is not therefore subject to section 58. I should say our sole concern is to ensure that the duration of any planning permission that is granted is aligned with the section 36 consent, and so that however it's achieved, and ultimately will be a matter for the Scottish Government and their legal advisors, that the 5-year period should be attached consistently across both. If one was erring on the side of caution, one might take the view that making a direction under section 58 would do no harm if it transpires that the proper view is that section 58 is not applicable to time-limited consent, but we certainly wouldn't want anything to fall through the cracks, so to speak.
I'm wondering, you've given me extracts from section 41 of the Act, which still implies that using a condition on a planning permission in the normal sense could address time periods, even though the direction under 58 now exists. Would you have a view on the use of a condition if that was found to be a good solution to get around this particular legal query?
I think if you are of the view that section 58 does not apply by virtue of the fact that this would be a time-limited permission, I think in those circumstances it would be competent to attach a condition which would regulate the duration of the deemed planning permission, and in that scenario we would ask that that condition would be allowing for a 5-year period, and it could be worded in a similar format to the condition that I think is condition 2 of the section 36 consent.
Last question, just when I have lawyers in the room, because I'm interested, is if you said nothing, if there was no direction and no condition, and this deemed permission is only deemed by virtue of section 36 of the section 36 consent, would it be the end of the world if there was no reference to it? Would it by default still be bound by the section 36 condition on time commencement?
My own view would be that it wouldn't be the end of the world if the deemed planning permission was silent, and the reason for that being that the section 36 consent is time limited, and commencement of development would need to happen under section 36 consent within 5 years, and the description of development there specifies that development must be above 50 megawatts. So in practical, the practical effect of that is that you couldn't implement one without the other, so to speak.
Thank you. That's very helpful. That's given us a good background, and we can take forward that and see if we need to adjust how we set out these matters to ministers when we make our final report. That takes us on to the conditions that are now where there's some level of dispute between the council and the applicant. And the first of these is condition 7, which is about the consequences of the development failing to produce electricity. I'm seeing a finger point from Mr. Fraser. Do you have a view on this?
Sorry, ma'am. No, I was just fiddling with because I can't, for whatever reason, get the external camera to work. I was fiddling with something on my laptop, and I wasn't intending to distract you. I apologise.
Apologies, I just saw your hand waving in front of the screen. Sorry, I just distracted.
Unfortunately, for some bizarre reason, the camera on my laptop is right down by the keypad, which is the worst place for it to be, really. But I'm sorry about that.
Yeah, no, that's fine. It's fine. I just didn't want to miss something important.
I'm just relieved Mr. Fraser wasn't about to disagree with all of my submissions to this point.
I'm not clever enough to do that, Mr. McGovern.
Okay, so we're back to condition 7, and it's about the consequences of failing to produce electricity from around 50% of the turbines as installed. If I'm summarising that quite a bit. I've also in my agenda said that there might be a need to look at conditions 6, 8 and 9, because they all sit around the same matters of decommissioning and of individual turbines or the whole development. But I'll take my questions really. I'm going to ask the council, I think, because obviously it's their condition really that it's been presented as their suggestion, and to just try and get a handle on it. So if we're looking at briefly at condition 6, we see that as an individual turbine fails, the council is reserving the right to go in and decommission the site on a turbine by turbine basis, and the applicants are not disagreeing to that condition. They are content that could stand. So at what point do we need condition 7, and why would it be necessary to look at decommissioning the whole site, which could still have operating turbines, at the point where we get to 50% of the turbines still active? So can you really give us a wee bit more of an explanation for that, please?
Yeah, of course. In terms of this condition, it's something that we have applied for a number of years on planning application scale developments, and I believe there are some Section 36 applications that do have a similar condition on it. Essentially, what we are looking at is if, for example, 50% of the turbines have had to have been or no longer produce the energy, you're getting 50% less of the benefit of the scheme, but potentially with still all of the visual impact or a lot of the visual impact of the scheme. So it affects the balance effectively in terms of whether the development is still an appropriate scheme in relation to the benefits and disbenefits of the scheme.
I would want to draw you to the reason that you give for the condition, because the reason doesn't indicate anything to do with environmental impacts. It's really just looking at putting in place appropriate decommissioning arrangements, and not about examining the overall assessment of benefits and disbenefits as you've just described. So I was wondering, I didn't get from that from the reason.
I think from the reason that we've got there, it's an oversight on our part in terms of the reason that we have set out in the document, and I apologise for that. It should be a much more similar reason to condition 6, rather than that set out in condition 7.
Sorry, I don't understand that, Mr. Heinsohn. So condition 6 reason is to ensure that any redundant wind turbine is removed from the site in the interests of safety, amenity and environmental protection. But that's not what you're asking them to do with number 7.
Yeah, I think what we probably need to do is provide you with an alternative reason to what we've got in either 6 or 7 to outline our what I described earlier about that kind of about that balance exercise, and if we're able to do so in writing within the next few days, I'd be happy to do so if the reporters were comfortable with that, and we can pass that to the applicant for their comment as well.
I don't really have a problem with that additional reason coming in, because obviously it will clarify the matter you've raised at the hearing. But I'm still trying to decide or get a handle on why 50% and not 75% or 25%, but why this point in the number of turbines, and also taking into account this particular site where we have 13 turbines at 50%, say we're at turbine 7, there could still be 6 turbines still functioning, and 6 turbine wind farms are not uncommon in terms of the landscape and in terms of the benefits offered in terms of electricity generation. So I'm just looking at the 50% now as a specific question.
Okay, so in terms of the 50%, we generally do seek to put 50% on the scheme, but we on schemes just as a kind of easy to refer to number more than anything else, but we do or we can look at it on a case-by-case basis. So for example, there's a public local inquiry coming up on another Section 36 scheme where the applicant has agreed to the condition in principle, but they've agreed that it would be 60% of the turbines would have to fail to generate before they would remove the entire scheme. And we could potentially look at an alternative to 50% on this scheme, given that it's an odd number of turbines. That other scheme that I referred to is also an odd number of turbines. It's a 5 turbine scheme. So we had agreed a 60% threshold on that condition there. And in terms of the specifics of this scheme, without advancing any specific evidence on visual impact, I think 6 turbines, depending on which ones they are, in relation to the position within the development, they may still have significant visual impacts as a result of the development, and may not be acceptable. And therefore it affects that balance of the benefits against disbenefits of the scheme.
Now you've heard that kind of additional explanation, does the applicant have a view on the acceptability of that condition? Does that change their view regarding the use of the condition as a whole, or whether or not there are amendments that would be acceptable to them?
No, ma'am. Unfortunately, it wouldn't change our fundamental view. Any alternative percentage would still, in our submissions, be arbitrary and presumptuous. It would be not scientific in any sense, and it would presume adverse impact. And I think, as you're suggesting, it may well be the case, depending on which turbines are removed, that the visual impacts may well be improved. As to the point around balance, even with fewer turbines, there would still be the benefits, which would still remain significant. And I have to say as well, this concern is, Mr. Hinson referred to some other Section 36 consents. My understanding is that those are schemes that are also in the Highland area and will be schemes where the applicant, for reasons of their own, have chosen not to fight this particular condition. It's not a condition which is routinely imposed by the Scottish ministers on Section 36 consents, and it's not a condition which is imposed by other planning authorities. It seems to be a unique concern of the Highland Council, so we would still oppose the condition on that basis. And I would also direct the reporters to the recent Section 36 case, Galtaclay, which a number of people here also participated in, where this condition was debated before the reporter, Mr. Seaton, and that's CD 2044, and you'll find in paragraphs 94 to 99 of his report his findings, where he agreed with the applicant's position.
Opening up the document unnecessarily, was the condition removed in its entirety or amended in any way?
It was removed entirely.
Does the council want to come back on that issue at Galtaclay at all?
No, we advanced some similar argument at Galtaclay as we did as we are today.
I referred to the issue of condition 8 and 9, but only in the sense that I think the misnumbering of a cross-reference, which I think you've corrected in the 23rd of April version of the conditions. So I think that's been sorted. But I just want, when we're looking at this issue of decommissioning and the financial value, and I just want to refer you to condition 9 just briefly. And this is nothing to do with the dispute, but while we're looking at these conditions, it's part 2, where it's about the review arrangements for the financial provisions put in place to cover the cost of decommissioning. They're going to be reviewed every 5 years unless an alternative frequency is agreed, and therefore increased or decreased to take account of any variation in costs of compliance with restoration and aftercare obligations. I'm wondering if that sentence, and I'll put this probably to the council first, is sufficient to pick up the point when the final decommissioning plan is put in place, because obviously that's a point where there might be the most accurate version of the decommissioning arrangements, but it's not specifically referred to. I'm wondering, do you feel that last part of the sentence would pick up that point in time?
It should do, but I appreciate that there could be more clarity and then more certainty in relation to the final decommissioning works. What we tend to do with the reviews is we ask the applicants to undertake a detailed review of each review point of the likely decommissioning methods for the site and the associated costs with those. And then each review period, we then also add on a level of interest going forward based upon the BCIS all-in tender price index to be able to ensure that the council aren't left out of pocket, for example, as a result of construction inflation. But I do agree that there could be greater certainty in there. So perhaps a point 3 in that condition, which would address matters in relation to the final decommissioning and restoration figures. And that could possibly set out that needs to be agreed within X date of the potential decommissioning of the site.
Obviously, I'm not wanting to particularly start writing conditions as a part of the hearing. Would the applicant be agreeable to some form of reference to the point in time when the final decommissioning plan is approved, that is added to part of the review arrangements?
I can see my client nodding, so I'm taking it that there would be no objection to. I entirely see the point that the alignment of the 5-yearly cycle of reviews might not fit well with the trigger for the final decommissioning plan. So we'd have no objection to ensuring that those two events can happen at the same time.
Thank you. I think that's covered condition 7. Are you happy, Ms. Haywood, that we've picked up the points there satisfactorily? Yes, thank you.
Can I just, sorry, Ms. Cook, can I just ask the council then? You've said that you would give us a reason, a new reason for condition 7, and also a third section to condition 9. So can I ask that you could do that with, agree that with the applicant and do that within 7 days?
Yes, of course, that's no problem.
Thank you.
Thank you, that's great. Thank you for that addition. The next item is item 4, and it's the condition on the compensatory planting arrangements and I deliberately included a little bit of policy evidence on the control of woodland removal to allow us to look at this condition. But I see from the changes made that you have picked up a lot of the points that I was going to raise on this, that the original concern was about this condition 15. The original concern was about the trigger point being the felling activity. But that's now seems to be agreed, and you've added in a great deal more detail about what the compensatory planting should include. And to my mind, it appears to be picking up these policy considerations from the council's own internal policy, other than the requirement to secure all this before a permission is granted. Now, Mr. Heinzen's evidence earlier was that that would be acceptable and that is how the council normally does that. Can we just confirm that everybody's agreed that that it's sufficient that these matters all be deferred to a condition stage rather than before the decision is issued? The applicant in first case.
Yes, we're content with the approach per the wording of the revised condition.
And I'm assuming, Mr. Heinzen, obviously you've already said earlier that you're happy with those arrangements, so that's fine.
Yes, happy with that.
That's good. That now takes us to item 5, which is condition 18. I'll just bring this up. And this is about whether or not the external transformers should be within the turbine structure or as installed as a separate structure or kiosk that sits at the foot of the turbine, I think, normally. Now, I asked the question in my agenda as to whether or not they form part of the proposed development. And the reason for that is that they are there in the 2013 description of the proposal in the initial environmental statement, but the reference to them diminishes as you look at the amendments that made in 2015 and then 2019. So it was really just to, it's a part of the difficulty of the project being amended, and whether or not silence in the 2019 documents infers that something is now dropped, or whether it's still being included from the 2013 time.
No, silence does not mean it's been dropped, and the general approach, and I think this is explained, I certainly hope it is, in the introductory text of chapter 4, both of the 2015 FEI CD1 to 1A and chapter A4 of the 2019 FEI CD131B. They both explain that save as set out in that chapter, then all details of the project remain as set out in the original 2013 ES. So unless changes are identified in those subsequent documents, then the position is as set out in the 2013 ES, essentially.
I see from that that whilst you weren't definitely proposing an external transformer, you said it was likely or a possibility that that particular arrangement. Mr. Mason's evidence was that I think he'd considered that, or that's in your hearing statement. I think that considered the impacts of that. So we'll probably just turn to the council now and find out why, in particular, the external transformers are giving them a concern in terms of, well, what their concerns are. I think it's visual clutter is the reason given in the summary table.
Yeah, it's as simple as that. It's visual clutter and the potential additional visual impact, albeit minimal, that these may have in combination with the turbines themselves. As a council, we have taken the approach over a number of years to seek that these are not included within developments, particularly where there are viewpoints from more elevated positions, which I appreciate there are not a huge amount of elevated positions in close proximity to this development. But we can, for example, if I could, it's unfortunately not on the list, if I could cite the Koromoili and Loch Lukut wind farms in Russia, so just near Gov, where if you are on Little Withers, for example, it's clearly discernible. The transformers are clearly discernible from that kind of proximity to the development. And what we have seen as a council through practice over recent years, where turbines have been getting larger and larger, as they are becoming larger, the towers are obviously becoming wider, and there's more scope to fit them within the towers of the turbines. And I would say the majority of wind farms within Highland do have the transformers internal to the towers. Notwithstanding, obviously, there is the health and safety executive advice to the wind farm industry on this matter. And if it comes down to a health and safety matter, then we would defer to that. But it's certainly our preference to not have such features, additional features within the landscape.
Now, I appreciate I had a look at the health and safety document, and it is dated 2018, so it's comparatively recent in terms of turbines that are now built and complete. Does the applicant want to come back on their concerns regarding that piece of advice and their experience of external transformers and internal transformers?
Just briefly, ma'am, yes, I think that the wording of that Mr. Hinson wants to include isn't discretionary, it's mandatory that the turbines then transformers would be internal, so it wouldn't allow for that discretion in the face of the health and safety considerations that have just been mentioned in any event. So we would resist that wording. But the more general point is that in order my submission, one should be slow to impose conditions which are constraining or curtailing the development as proposed. Such conditions must be necessary. Although Mr. Hinson has referred to visual clutter, he's also fairly said that this situation may not be comparable to other sites that he mentioned, and that there aren't many elevated locations where you would get appreciation of that, and where you might see the turbine that would be from such a distance that you may not perceive that visual clutter. Nowhere in the Highland Council's evidence is there any submissions to the effect that there would be any significant environmental effects as a result of the external transformers. So I think, in short, the Highland Council hasn't really made any case as to why such a condition or such a constraint on development is necessary in the circumstances of Strathy Wood, bearing in mind the health and safety factors that were highlighted in the HSE letter.
Do I take from that that if the condition was worded in a way which asked for details of the external transformers, if any, would be a more acceptable way forward?
One might take the view that the external details might already be covered in the generality, but we would have no quarrel if it was made plain that as part of the approval of external appearance of the turbines, that also included the colouring, for example, of any external transformers.
The appearance of ancillary structures is a separate condition at 19. I haven't specifically referred to that, but obviously they include the control building, substation, or other above ground ancillary infrastructure. Were you considering that the transformers might fit into that description?
They're not mentioned expressly, but I think you could treat them either as falling under that condition 19 in general terms, or if you prefer, in the interests of clarity and for the avoidance of doubt, and they could be referred expressly in condition 18.
Does the council want to come back on that issue of how it might be handled if the transformers, the option of internal and external transformers is to be kept live at this point?
I'm quite content with what you said, ma'am. I think it's if it is to be included within the development, it could fit either comfortably within 18 or 19.
And that takes me, if I go back to condition 18 again, and this is something, it's not a dispute, but I was reading under the words furthermore. Obviously, we've got the disputed sentence about internal transformers. And then the second point is B, the blade tip shall not exceed 180 metres to blade tip. I have a feeling that should be the turbine height, or the overall turbine height shall not exceed 180 metres to blade tip. Would you agree that's the purpose of that sentence? Yes, I'm getting nods.
Yes, yeah.
And this is me and my particular tidy mind. When we pass down, we find another condition, 20, also called appearance of turbines, where it refers to the direction of rotation of the blades or the rotors. I'm wondering whether or not would parties have any strong opinion if that requirement was tucked into the other constraints or requirements for the appearance of the turbine.
Certainly, if it would ease your tidy mind, ma'am, if I put it that way, then we'd have no objection to you doing so.
Okay. I don't know if I will, but it's I just want to keep the option open.
I'm all in favour of reducing the overall number of conditions.
And that takes us now back to condition 8, but for a different purpose now. And it's a particular concern I have relating to SEPA's consultation response. And that's the 13, see, no, it's not 1.3, I'm opening up the wrong document. No, 3.4.13. They very helpfully summarise their conditions in an appendix, and they recommend at condition 6. It's a strange thing. Wording which would suggest removal of only above ground elements of the scheme upon decommissioning would therefore not be acceptable. And I was looking at the conditions as you've presented them, and it was giving me a little bit of concern. Is it now? Was it condition? Is it condition 8 or is it condition? Is it condition 10 on micrositing?
I think it may have been condition 8.
It's condition 8. Yeah.
As originally worded, there was an exclusion in relation to access tracks and foundations, which might suggest that they would be left in situ come what may, which I think was SEPA's concern. And we did seek to address that by amending the wording in the more recent version in order to leave it open, essentially, so that there's no mandatory position either way, and depending on best practice and SEPA advice at the time, they could either be left in situ if that's felt to be the most environmentally beneficial position, or the alternative.
So by using the word or relevant parts thereof, you're looking to keep your options open to negotiate that with the council at that point in time?
Yes, correct.
Right. Thank you, that's great. And that takes us on to conditions 10 on micrositing. Now, my first question was really just, again, it's for my benefit, was about the reference to the meteorological mast. There's one on the site already, and the proposal to retain it or relocate it is in the original 2013 ES. But again, it's one of these things that kind of disappears a little bit, and it doesn't seem to appear on any of the layout plans of the infrastructure. But is the council and the applicant happy that the Met mast continues to form part of the proposal, either in its original position or in a new position? Well, that's the council first.
I'm happy that it still is part of the proposal. However, it would be useful to have an updated site layout plan in due course. which would set out its location, and whether that needs to be secured by condition is perhaps up to yourselves. I think my preference would be that it is secured by the location of the met mast is secured by condition, unless Mr. McGovern can tell me on which plan it is shown.
We would have no difficulty in providing a plan and secure that by condition, if that would satisfy the council.
Having a look at it, it might well tuck in nicely into any of the conditions that are asking for the final layouts to be agreed. So it could possibly fit into 10 on micrositing, or possibly onto the ancillary infrastructure condition that we were looking at earlier at 19. Yeah, I think there'll be a place for it to fit so that the final position of the met mast is just covered. It's just so that it's secured and that everybody agrees that it has a permission under section 36 or the deemed planning permission. That's fine. And the next part in condition 10 on micrositing is again, it's a SEPA issue. If I explain to you what I think I'm worried about first, and then it might make more sense. Having read through some of the ecological concerns with this site, there is an issue that there's some of the existing infrastructure in the site, I think it's tracks and things, have to be upgraded for the purposes of the wind farm development, and they lie within what is agreed to be the buffer zones associated with these sensitive groundwater areas. And as my reading of the conditions means that you can't microsite any of the infrastructure to go into those areas, which is fine. That's meeting the SEPA's expectation. But they were quite keen that you didn't microsite anything that they have already agreed can be in these buffer zones, the distance, and I think it's in condition 4B of SEPA's response. It says, except we're already agreed. So that's I think these bits of infrastructure that are going to be upgraded, so that these are not microsited, shall not be relocated. And I was really looking to see if we can make sure that requirement not to move any of the agreed infrastructure that's in these zones as well. Would the applicant have a problem if that is tucked into the final wording of the condition? So it's not just about micrositing items into the buffer zones, but that committed infrastructure remains as in its agreed position, where it already lies in those areas.
Well, I must confess, I hadn't quite read SEPA's submission as going so far as to say that anything that was already in those areas as identified on that plan could not be moved at all. But this might be one of the areas where, since we're dealing with technical detail, I might see if one of the other participants for the applicant might have a view on whether that would be acceptable or not. We do have Jean Curran and Lauren Kellaway from Atmos, who are the EIA consultants. They may be able to assist.
Oh, yeah.
Not Gary, maybe I can.
Or Ellery, indeed.
Yes.
You go first.
We might just have to take this away and have a look at it, because if we microsite certain infrastructure, it might have knock-on effects on other infrastructure. So we just need to look at that before fixing the positions, I think, and maybe agree that with the council.
Yes, perhaps that we could add that into the matters you were going to look at under the other conditions. It's really just to make sure that SEPA's expectation under 4.1b has been properly covered in that set of micrositing restrictions. That's all I'm looking for. If you and the council are able to agree that that's properly reflected, I'll be happy to take that as an additional submission in the next 7 days or so. Would the council be happy with that?
Yep, quite happy with that. I think one way that this matter has been tackled previously in decisions has been to set out a table within the condition of those of each turbine or piece of infrastructure, and set out the grid reference for that. And then for each one, you could then say what the microcycling limit is next to it. But I'm happy to discuss that with the applicant.
Well, that's fine. I'm just looking to make sure that when we report this to ministers, we haven't overlooked an important requirement of a statute consultee. So that's really the main purpose of asking the question. It takes us now to item 8, which is condition 12. I was asking a question about traffic management issues for traffic management plan for final decommissioning, but I see you've already tucked that in elsewhere into another condition, so I'm happy with that. Condition 16 was about forest waste and the potential that the habitat management plans would need to allow for some brash, this woodland waste to be incorporated, and I see you've already amended the condition to pick that up. Condition 30 was about SEPA's requirement to ensure the redundant River Ure crossing was removed, and I see you've already adjusted the amended condition to pick that up. And that takes us to the last item, which is 11, and that was really just, I'd queried again, because of the 3 versions of the environmental information, that we actually were referencing the correct description, and I think you've given me a more accurate reference document for that, so that's covered as well. And I was just asking about Annex 1, 2 and 3, and to make sure I understood which bit was Annex 2, because I don't think it was labelled. So just, I've put here, is it the list of conditions? So maybe somebody could just confirm that.
It is.
Gary's nodding. And that takes us to item 12. Now that was really just any other matters relating to conditions that have arisen from the hearing. And we spotted something, it's a very minor point in the 4 conditions relating to the section 36 consent. And it's item 4. And you'll see that you are to provide written notification of the nature and timing of the incident to the planning authority. The model condition, however, expects that notification to go to the Scottish Ministers. I was wondering if there's any conscious decision taken there to introduce that wording, or if it's just an error. Perhaps you could clarify.
Certainly from my perspective, that's an error, ma'am. It wouldn't more normally be notification to the Scottish Ministers, so I'm grateful to you for pointing it out.
And from the council perspective, yes, it would be it should be to incident reporting to the Scottish Ministers on that matter.
Ms. Hayward, do you have anything else you've spotted or anything you want to clarify? No, that's fine. And well, I don't have any other points. Is there anything else to do with the conditions that you want to raise just now before we finish? Nope, nobody's raising their hands. So really just to remind everybody, we've agreed that within the next 7 days we'll get some additional wording for the SEPA concern from their condition 4B, and possibly, yeah, I think that was all, wasn't it? Yeah, I think that was all we were following up. I think there was other things from the first hearing session we're going to come back in the next 7 days as well. Ms. Hayward, sorry.
It's the reason for condition 7 and
the reason for condition
part 3 for 9 as well. Right, so is everybody happy that that's us covered all the matters in the conditions? Nobody's raising anything else. Well, I think we've done very well there. We are finishing at 12:40. That's super fast, and we're going to finish before lunch, which is excellent.
So thank you very much. As I said to the participants earlier, thank you very much for making the effort to get the virtual meeting system to work. It's much appreciated. Thank you to all the witnesses who've taken time out to help with that, and also to the applicant for preparing the comprehensive core document system. It does help when you're working remotely to work from the memory stick. It saves us relying on the broadband connections to get into the main document libraries. So really just going to bring this matter to a close, and we'll hear from you in accordance with the agreed time periods that we've set out over the last few days. Thank you very much.
Thank you.
Thank you.
Thanks.
Thank you.